Alright, so last week I was talking with a high school student and she wanted to know whether or not a teacher can go through her purse. And I thought to myself, if she had this question, I'm sure there are other students out there or maybe their parents who have the same question. So in this video, I'm going to talk about whether or not a teacher or principal can go through a student's book bag or purse. Coming up. Hello, my name is Clyde Guilamo and I am a lawyer in the Chicagoland area, and in Law Talk for Non-Lawyers, we talk about the law in plain English. And in this video, we're going to put on our backpacks, head back to high school, and talk about privacy rights of students. In March of 1980, a teacher at Piscataway High School went to the girls' bathroom and found two girls smoking cigarettes. One of those two girls was T.L.O. That teacher took the two girls to the assistant principal office. The other girl admitted it right away. She had committed the violation, but T.L.O. denied it, saying that she was not involved. So the assistant principal decided to search her purse. In searching her purse, the assistant principal did in fact find cigarettes, but in addition to that, the assistant principal found rolling papers, cannabis, a pipe, plastic bags, a significant amount of money, an index card that had the names of students who owed her money, along with other items that showed that she was dealing drugs out of the school. That assistant principal reported it to her mother, but also reported it to the local authorities, and she was charged with a juvenile delinquency case. Her savvy lawyer, seeing that she had been charged after this search, went ahead and filed a motion to suppress the evidence, all those items that were recovered from her purse, saying that this was an unlawful search. And that's going to begin our legal analysis. Alright, so we're going to start our legal analysis looking at the Fourth Amendment of the United States Constitution, and that is your right against unreasonable searches and seizures, okay? Now, that amendment applies to unreasonable searches and seizures by the federal government. It is through the 14th Amendment that applies that protection that you have to state actors, okay? So that's your local law enforcement. But what it does not apply to is to private citizens. So if you were to catch your mom snooping through your phone and you were to tell your mom, hey, you're violating my constitutional right to privacy, you would be wrong, because those rights do not apply to private citizens like your mom, okay? So she is not violating your constitutional rights. But then the question becomes, what happens in the place of a teacher? So then, is a teacher more like your mom and the Fourth Amendment protection doesn't apply to your teacher? Or is your teacher more like a police officer, in which you do have a protection against unreasonable searches and seizures? This was the determination that the Supreme Court needed to make back when this case, New Jersey versus T.L.O, was decided. And what they decided was that your teacher is more like a state actor, just like your local police officer, okay? So the student does have a legitimate privacy interest that must be respected by their teacher. So the next question becomes, well, hold on a second. That teacher or that principal did not obtain a search warrant. Therefore, the evidence should be suppressed. And if you thought that, unfortunately, you would be wrong. Because the same way that you have a legitimate privacy interest here, there are many things that you can take to school that don't necessarily constitute as contraband, but you wouldn't want your teacher or your other classmates knowing you have. Things like a diary or a journal, things like personal hygiene items, or things that you may need for an extracurricular activity. Okay, those are items that you may not want public, and you have a legitimate privacy interest. But the school also has a very good interest as well, and that's keeping their environment safe, a place where people can learn safely, okay? And that interest is very compelling as well. So what the Supreme Court decided was they were going to carve out an exception here. They weren't going to require teachers and principals to go to a judge and present their evidence for finding a probable cause. They were going to allow teachers to be able to search students without first going before a judge. So they carved an exception here for teachers and for principals. Teachers and principals do not need a search warrant before they go and they search their kids. However, their search must be reasonable. There must be reasonable, articulable facts to explain why it is that they are conducting their search, okay? That was the requirement necessary for teachers and school personnel conducting searches of students, okay? So long story short, yes, a teacher can search a student, but before they do so, there must be reasonable suspicion that that child is either violating a school rule or committing a crime. Without those things, whatever items were recovered would in fact be suppressed in the criminal case. That's it for me. If you have any other questions, feel free to leave them in the content below.